when other families and students contact me and there's only been one abuser, having to turn down those cases, even in some really egregious cases. I probably would not have been able to take Jaden's case and make a federal lawsuit on her behalf because of the stringent standards that apply to Title IX cases, and that's what this falls into, generally speaking, Title IX and sometimes 1983. And that's even a question, unless there wasn't that second abuser, because of the notice requirements. The number of families that I say no to, I had 12 calls last week of educator sexual misconduct, people seeking lawyers. I did not take a single case because you have to have the track record. And let me tell you why, in this case, something that brings the picture and why it's so hard to get that record. Jaden told you about her two abusers at that school. And but she didn't mention that at the same time, 2 days after she reported the first abuser, a separate student brought in to the principal of her same high school a picture with nudes of the high school librarian that had been sent to one of their students. That librarian was reported then within 2 days of our first outcry. It sent everybody into shambles. So Kerrville ISD had a problem, but they didn't view it as a problem with educators committing educator sexual misconduct. They had an image problem. When we test with, excuse me, I'm sorry, if you would mind if I finished. I think it was exactly this day last year that I put the Title IX coordinator and superintendent of that district during Jaden's time on the stand. And I asked, what did you do? You had a crisis because you had not one, but two. This was an image crisis. What were you, the Title IX coordinator, doing in your Title IX capacity? Oh, I didn't do any of that. I delegated that to the assistant superintendent and the principal. My job was to protect the school. And what those people told us then on the stand in the days during that trial was that, oh, well, I didn't know I was delegated those responsibilities. And then when they were in the meeting where Jaden and her parents are told to go to take it off campus so that it doesn't look bad that she's spending time with this one teacher, the only teacher in her mind that is giving her safety. They said, well, I said, did you tell them about the repeated boundary crossings that you were having to tell him? You were giving him instructions not to cross boundaries, and he was disregarding, and he was being insubordinate to you. Did you share that with the family? No, I didn't. Why not? Well, we didn't want the family to use it against us.
The school district said that?
Yes.
Okay. Let me open it up to members' questions for the panel. Hang on, I've got a couple of questions. I see Miss McDonald sitting back there, and we've discussed this in our public education committee, and I'm sure she's going to make some comments on this later. But was this the police department when an initial report was made? I'd like to know, was this a school district police department, or
No.
was this the local police department?
It was under an MOU with Kerrville's police department, and that ended up having some very interesting implications on our case, because one of the witnesses that we called definitely had some changes in his testimony from what he told my co-counsel, who was the former Kerr district attorney, about what the school knew and did not know in person when they sat down and discussed things outside. But after he talked to the school district lawyers, he came into his deposition and started screaming that my co-counsel was unprofessional for having asked him questions, informing him to his role in the case, and that it was so unprofessional. And he denied telling my co-counsel that, yeah, the school told us that, you got to watch out for her. She wants, and that changes the tenure of the case, because that's what we see.
Of course.
It's hard to get the records. Getting a full set of the real records, almost impossible.
When Jaden, you can jump in here, Jaden, as well. So when you initially decided that you were going to tell somebody at the school, who did you tell? Your principal?
So initially, I ended up telling the other teacher of ROTC. And that teacher, to this day, I have contact with because he is an actual adult. And
What did he do when you told him?
I left because I know I just.
Do you mind me asking you how old you were at the time?
I was 16 when I told about the first.
What did he do when you told him?
He immediately got up, went and got that teacher, took him to the office and said, tell them, tell them what you did.
Okay.
And then the teacher was let go, the one that abused me. But the principal did tell me when I said, how do you not believe me? You fired him. She said, well, we didn't fire him because he hurt you. We have no proof of that. We fired him because he just emailed you too many times.
So that teacher, do you know where he is now?
Yes.
Probably teaching somewhere?
No, he's working for the Air Force again, teaching students about flight.
Okay. What happens a lot of the times is they will terminate an educator for another reason. You're all shaking your heads like I'm telling you something you already know. They terminate the educator for another reason or let them go quietly, and that's how the pass the trash happens most of the time. They'll show up in another public school or in private school in many cases, or in another state, and we're working on some other options to try to fix that do not hire registry. So what happened next? I'm trying to understand. Clearly there was a breakdown in this situation. The school district had actual knowledge of abuse that had taken place, and it looks like they botched this at every step of the way. I
mean, it was a failure on every single one that was in an administration role. Once the second student came out, there weren't even really rumors yet of what was going on. 2 teachers weren't showing up. Okay, they said personal leave, no one questioned it. Students weren't making rumors yet. So they send out a letter to every single student's parent saying what happened. Do you know how fast students can put together the student that was near a teacher the most? Yeah. They're not dumb. And so walking down the halls, it was like a scene from a movie after they sent out that letter. Pointing, whore, bitch, slut, you ruined this school, everything. And thankfully, the principal made sure to tell me that kids will be kids. So wasn't her fault. Understandably releasing that information, which I did go and make sure they didn't have to send out that report. That was them just wanting to do whatever they wanted to do to protect their image.
Mm-hmm. Representative Schofield.
I have 2 questions. The first one's a real quick one for Ms. Brown-Rodriguez. My colleague and I were looking at your chart, and in the disposition column, most of the entries are D and O, and we didn't know what that meant.
Do not open.
So they just didn't even do an investigation?
That's correct.
Okay. Baden told us numerous different people, so not the same person multiple times, numerous different people said to her basically, you shouldn't have done something, it's your fault,
Right.
It wouldn't have happened if it wasn't for you. And that's easy to say to a kid. As a lawyer, I could say it's usually different when you get them in deposition or on the stand. So what did those same people say when you got them under oath?
Well, let me first start with what they told the SBEC about the second teacher. So, because their words were that the female student, Jane Ray, was the victim of an inappropriate student relationship that was reported in September of 2017. They're referencing teacher 1. So that's their kind of why we're writing you a letter, because they refused to believe that this guy, they said he had a personal relationship with her parents. Her parents had met him once through a professional thing, but the family really glommed on to him, and grooming happens, okay. Well, it is the school district's position that Mr. Chatinier is a teacher, and he does not have the credentials to be a counselor. Furthermore, it's the district's position that all students should attend their regularly scheduled classes. And they said that he had, ignored their instructions to make her attend the regularly scheduled classes. And at the end of the day, the next words they say is, and I'm sorry, my computer just moved to the wrong document. Make no mistake. Oh, here we go. Now I got page 2. They go through a timeline of the events, and this is shortly after the principal has been told that I saw a statement made that Jaden and the math teacher hooked up. And that gets reported to the principal. She also informs the assistant superintendent. That statement is made on the same day that they're wearing matching T-shirts from an out-of-town Volkswagen car convention. So they call him in, and they dismiss him because he hasn't been making sure she's following professional directions or boundaries. This is what they tell the TEA after they spell out this timeline of all the things that Jaden didn't follow. At this time, we have informed Mr. Chatinier that he would recommend his termination to the superintendent for failure to follow multiple verbal and written directives, being untruthful, and for failure to appropriately report a student's threat of self-harm. And then he said, but make no mistake, to be clear, there is no claim of or evidence that a sexual or romantic relationship exists. They said that to the TEA when they reported. So they wrote a letter, and they outlined all sorts of things that my client did, but they did not outline that they had been informed by a student that she saw a comment being made that they hooked up. They did not inform them that 3 weeks prior, the school counselor had written a letter to her principal because she walked in to go pull a student from his classroom for something else, and it was a class time that Jaden was not supposed to be there. And she saw her kneeling at the base of his chair behind his desk on her knees, in such intense conversation together while he was sitting in his chair that they didn't even notice she was standing in the doorway behind him.
And this isn't students gossiping, this is the school counselor.
This is a school counselor and this is what her takeaway is. And she's very careful about what she put in writing. The clear message is, I'm concerned about Jaden's actions and so forth. Not, and it makes me very uncomfortable, but I'm not going to go so far as to put the sex word down. Mm-hmm. And that's what you see at trial. So when we got to trial, and we're one of the few cases that can get there, and it took us 4 years and $150,000 in expenses to get there. And those witnesses say, oh, I saw that this happened, but no, I didn't think it was sexual. I didn't think it was sexual. The district's own expert testified that by the time they finally do say you're out unless you resign, that they had 0 more reasons. They needed 0 more things to figure out this guy was being sexual with this child. And you know what happened? We tried the court made us put on all of our witnesses in 3.5 days, and gave us 15 minutes to look at a summary or at a judgment as a matter of law motion, and granted it because he said, you know what, they say that they didn't know it was sexual, and they did something, and that's the thing under Title IX. The standard, doing something is enough to get out, and it doesn't matter. And they all know that. So that's why they're always willing to do a little something. I've had them say things like, well, just because we didn't know what we were
Check out this new update that just made streaming so
really bungled it up. We did try. We did something. We should be good. And that's just not enough. It is a right without a remedy.
Now, I would think that obviously the abuse is the worst thing that happens, but the second worst right behind it is them telling you as a kid, well, it's you. It's you shouldn't have done that.
The victim shaming is,
And
So what did and it's just a good way to control you and to keep you from wanting to do anything. So once you got those same people who had told her that, and you questioned them, what did they say they said?
well, they say things like, I did not say that she was complicit. I deny that I told the teachers that she was complicit. However, I've got the contemporaneous email that's the mom reporting that this has been informed, that your principal said she's complicit. But then in their word choices, they were saying, well, Jaden wouldn't listen to us. Jaden wouldn't listen to us. We were telling her not to do this, and she wouldn't listen to us.
So they even told you that in deposition or on the stand?
Yeah, the word choice
They didn't say
is
the teacher
always-
shouldn't have not done something. They said, we told her not to do it.
Right, and if you'll let me find my location, I can kind of give you an example of how exactly this. I am very uncomfortable that when I walked into the classroom, sixth period, she was kneeling so closely to his chair. I have spoken, Jaden and I have spoken about the previous situation as well as appropriate relationships with adults. I feel that we have given her every occasion to discuss her feelings, debrief her events and her suggestions, but I don't see she is truly implementing our discussions, suggestions to make positive change and to practice healthy boundaries.
that's horrifying. That's absolutely horrifying.
Yeah. And there's more, the reason I almost stumble and it is almost inarticulate to answer, because there is so much more. It's replete in all of the testimony you get. When we talk about the training that they did after, they were being told, the witnesses, when they're testifying, the way they describe what training they got right after the first two came to the surface and were public, it was, well, they were teaching us how to make sure that the students didn't do this to us. They were saying, what the students are going to do to you. And when I asked, what did they tell you about how to identify if somebody is doing this? What did they tell you to look for? And like, no, it's not about looking for it. They just told us how to prevent it from happening to us. And it is a teacher focus. The students are going to make you look bad. It's all about the covering of the preventing the students.
It's terrible.
Thank you, Mr. Chairman.
Members, other questions? Thank you each for being here. Thank you so much.
Thank you.
Committee appreciates and values your testimony. And again, Jaden, happy birthday.
Thank you.
You made a difference today. Thank you. The chair calls Timothy Woolsey, Callie McDonald, Stuart Baggish, and Monty Exter. So, Monty, I'm going to start with you, if I can. Members, for those of you that don't know, I imagine all of you know Monty, but if you don't, Monty's here on behalf of the Association of Texas Professional Educators on the bill. And Monty, I want to commend you for appearing in front of for being here, number one, but for being willing to testify on the bill and face questions from the committee. I wish some of the other groups had done so as well, but we value your presence today. So let me start with you. Again, Monty Exter, the Association of Texas Professional Educators on the bill. Is that correct?
That is correct,
All right, go
Mr.
ahead.
Chairman.
Yeah, thank you.
And let me start by saying, before I get into the rest of my testimony, I'm going to stay pretty close to the bill, but y'all had a wide-ranging discussion earlier about public education issues, about insurance issues with regard to public educators and others in that field. I'm happy to get into any of those questions if y'all want to, because I have a feeling I'm maybe the only public school person here today.
You are.
And so I've been doing that for a long time, and I'm happy to dive into those questions with you. So let me start by saying that As the largest association representing school employees in the state of Texas, and we are only in the state of Texas, we find it abhorrent that there is ever even one sexual misconduct that happens in any school, certainly in a public school. It is certainly the position of our members that anyone that would commit such an atrocity should not be an educator. They should have never been an educator in the first place, and they should certainly be removed from the education field as quickly as possible. So I've passed out testimony to you guys. I think many, if not all of you, actually got it in digital format before. I do want to tell you there is one little amendment that's in there that was some additional law that was added around some federal issues. And I just mostly, I think, want to talk very quickly about some of the things I heard earlier. So you talked about some of the liability issues and not being able to get to things. So let me say, going all the way back to the mid-'80s, you have been able to sue the individual employee. So to say that there's not liability on the individual employee is just not accurate. That is the case right now. It was the case then. Now, I will say that as far as I've been able to find so far, and I am looking, I will agree that it does seem that most cases that are going on the supervisor or the district itself are going to federal court. That is because that is where it is the procedurally most clear that you can also pierce immunity there. So it's not accurate to say that you cannot pierce the immunity in a civil case, but it is in a federal court setting, as you were talking about.
So you can't do so in state court?
I'm not sure.
I don't
We're
believe it.
looking.
I don't believe that you
Most
can.
of the cases that we've found are going to federal court is certainly clearer there. Let me also quickly say, because I know 2 minutes, that our actual primary issue with the bill is not any of what we've talked about today. It is that we read the third bullet under 118.002 to be extraordinarily expansive beyond the sexual misconduct issues that we're talking about here today. We read it effectively to encompass, well, all of the things that were actually in the layout, in that it encompasses any, so it's written in a way that sounds tricky. So it sounds like it's a negligence or above fault standard. But in reality, the way that it appears to be written, it is that you negligently through intentionally did an act, and that act resulted in harm. So may have intentionally done an act that was in fact normally fine, that resulted in injury. So I intentionally sent the football player out to the field, and while he was out there, he broke his leg. So our reading of the bill is that number 3 100% pulls that whole scenario into the premise of this bill. And that really is what we're talking about. And really from Representative Schofield's point of view is, you know, is that what we're looking at in terms of putting taxpayers on the hook? That
Sure.
kind of thing.
Well, that's certainly not the intent. And by the way, Representative Little, you feel free to jump in at any point if you want. Let me, before you do though, let's go through the panel of witnesses. It sounds like you've got a mic issue too, so we can get that figured out. Monty, thank you for your testimony. We'll come back to you in just a sec. Timothy Woolsey, let's start with you, and then Stuart, we'll come back to you. I've got you, Timothy, here testifying on behalf of yourself, testifying for the bill. Is that correct?
That's correct. I'm
All right.
actually testifying for my son who was abused.
Okay, I can't have you testify on behalf of another individual, so I've got
Okay,
you
then for myself.
just registered for yourself for the bill.
Okay.
All right, go ahead.
All right. So Texas Family Code Title V, Section 261.109 outlines the penalty for failure to report abuse. Subsection A1, a person who is a professional as defined by that section 261.101B, which teachers fit, commits an offense if the person knowingly fails to make a report as provided in this chapter. Subsection C, an offense under subsection A1 is a Class A misdemeanor except when the offense, except the offense is a state jail felony if it is shown on the trial that the offense the actor intended to conceal, abuse, or neglect. You guys are going to hear us listening or watching our son be abused.
I take serious issue with that.
Absolutely, it is definitely
Unbelievable issue.
not
the way to do that.
I'm sorry. And the superintendent told my wife yesterday that we would have a very different attitude towards this? I'm appalled by what I just saw. That is No, it's not. It goes against everything in the CPI
So,
training and manuals.
Mr. Woolsey, I gotta have you turn that off. I just need you, you can testify to the committee as
That
to,
is
to
your
what,
subordinate.
whatever it is we're listening to, but I can't have you play it over the microphone. So you could proceed with your testimony. And plus, I couldn't even hear it. So if you could share with us what
Okay.
it said.
So that is us sitting with Micah Gierke and Kim Beacon, which is the Executive Director of Student Support Services and the Executive Director of Elementary Education for Northwest Independent School District. Watching Principal McAdams and Assistant Principal Johnson of K. Granger Elementary pick up and carry our 6-year-old son by his arms and his legs through the hallway of the school in front of other teachers, then drug his legs behind him, shut him in an office with the two of them behind closed doors with no audio and no video, and then barricaded him in a room, which he then fought to get out of because he was terrified. This was covered up by the superintendent because TEA has opened up an investigation under 19249.14 because he never reported it, which, like I stated earlier, is a state jail felony.
Okay, thank you, Mr. Woolsey. We'll come back to you, I'm sure, with some questions. I appreciate your testimony. The chair calls Stuart Bagish. Mr. Bagish, I've got you here registered on behalf of yourself, testifying for the bill. Is that correct?
That is correct.
All right,
That
go
is
ahead.
correct. Thank you. As horrible as all of the testimony has made this problem appear to everyone on the committee, it's actually much, much worse because, in fact, throughout the state of Texas, anyone who is aggrieved in any way connected with a public school district never gets to go to court even for injunctive relief unless they first ring the bell and exhaust their administrative remedies before the school district. And oftentimes, the school district has time limits. There are many school districts with time limits as short as 10 days. I've never seen a school district with a time limit longer than 60 days. But that acts as essentially another impenetrable barrier that parents and families of sexually molested children have to deal with. They have to file a complaint with the school district that employs their abuser. They have to do it within 10 days. Oftentimes the parents don't know about it until the 11th day or later, and then it's dismissed. That acts as an impediment to the parents going into court for injunctive relief because they didn't exhaust their administrative remedies by timely filing it. And there's a labyrinth of rules. The school districts generally follow the board policies that are promulgated by the Texas Association of School Boards, but they have various blanks that they can fill in, and they all seem to be choosing the shorter time periods rather than the longer ones, and 10 days just isn't enough time for a statute of limitations on something as serious as sexual abuse of a child that the school district is responsible for putting alongside the abuser.
All right. Thank you for your testimony. Chair calls Callie McDonald. Callie, I've got you here registered on behalf of yourself, testifying for the bill. Is that correct?
Yes, that's
All right.
correct.
Go ahead.
So I want to open saying I find it really interesting that the people who were so caring about this bill that they cast a vote against it didn't want to look me in the face and tell me how much I'm worth. I'm interested. What's the number? If I had died when I was 16, if I had had better practice at tying a noose, my family would have paid for the casket. My family would have paid for the funeral. My family would have paid for the headstone. my family would have paid for their ongoing recovery, whether it be medication, therapy, whatever it may be. But then they have to face the non-financial implications as well. And I think that's worth a hell of a lot. A reporter from a local news station was supposed to join me today. She was going to testify as well. Unfortunately, she got called to a higher profile case of a coach sexually assaulting his student at a local school. So she had to go report on that. I know that we've noted the barrier is not impenetrable, but it's sure not easy to penetrate either. This is not easy. For me to be here today, the financial cost is about $1,000, including the hotel, because I testified on a few bills yesterday too. Additional costs of the 2 days include sacrificing time with my family, sacrificing my paid time off work, sacrificing every bit of patience I have in Austin traffic. And I've covered just about every step of this capital trying to find out where I am. It is not easy to come forward and testify. And it should not be the responsibility of the students who have gone through this to make these testimonies. We say we don't want to bankrupt the taxpayers, but you're looking at a taxpayer. No one had an issue bankrupting me. My parents are taxpayers. No one had an issue bankrupting them. The kids in school today will be taxpayers. Do not bankrupt them for something they have zero responsibility in.
Go ahead,
Thank
Callie.
you.
No, go ahead.
The point of all of this is this isn't fun for me. This is a sacrifice. It's a sacrifice I chose to make because I wanted to take part in doing the right thing, because looking around me, I couldn't find many people who were. As an adult, we have a responsibility to do the right thing, even if it's the harder thing to do, even if it's self-sacrificing. That means a superintendent has the responsibility, if not as a superintendent, just as a decent human, to tell the truth to the police when a child's being abused. The superintendent who lied to the police about me is making about $200,000 a year as a superintendent at another school. If a dog pees in the floor and you don't do anything, it keeps peeing in the floor. You can send it to your friend's house, it'll pee in the floor there. If no one does anything, the whole place smells like piss, and that's what's happening in Texas. There's a 10-year-old girl in a classroom right now, and no one is telling her that puberty will come with being seen as an object of sex, to be molded and formed into the perfect object for a 30-something-year-old man. He will work on her for years to get her just right. Most of us don't tell the truth. Most of us don't come do this. If you had to sit through the testimony of 1,000 of us today, which is probably a very small percentage of us, you would be here for days. I have sacrificed time. I have sacrificed hours and hours trying to get my documents together. I've spent hours reading these bills. Guys, if I was stupid, I wouldn't be able to do that. Not everybody is capable. Not everybody can stand up for themselves. The 10-year-old girl in the classroom today, in 8 short years, she will be walking across her high school stage graduating. And she will be a taxpayer. And hopefully she will be a doctor or a lawyer or a teacher. That's what we all hope. But she might not be. She might be just a waitress. She might be a, thank you. She might be a, she might be working in a call center and vomiting in the bathroom trying to hide her anxiety attacks like I was, because I didn't know how to get help. I didn't know what was happening. That 10-year-old girl will graduate and she might just have a job. She might be working a very necessary job that just doesn't make the ends meet enough for her to get the help she deserves. She needs to invest thousands of dollars into herself. She is a taxpayer. Alternatively, she might be married to the teacher who groomed her. Start looking around in Texas public schools. Start looking at how many of them marry their students. And then the school hires the students on as a teacher. Small schools, it's common. It's not unheard of, it's not uncommon. We think that might be the worst case scenario, but the worst case scenario is in 8 short years, that 10-year-old may be dead. I want you to look her in the eyes and tell her how much she's worth. Because I was 10 years old one time. No one told me what was coming for me. No one helped me avoid it. And when the time came for reckoning, the reckoning was mine to bear. If I had been a better planner, I would have been rotting in the ground for 14 years now. I would have been rotting in the ground as a baby. I would have been given no chance. So you ask me who's responsible to pay for it. I don't know, it's not me. Maybe it's the school's insurance. Maybe it's definitely the school when they cover it up, intentionally, over and over. You say we can sue a teacher who's done this, but I invite you to find a lawyer that will take that case. I don't care if it's hidden in some legal handbook somewhere where no one can find it, no one's doing it. So I'm sure if it's already available, you won't mind it being in the current language. Everything's bigger in Texas, and that includes our pedophile in school problem. It's not something to be proud of, but it is the truth, and it needs to be put on the table and fixed. So we're here to decide who's responsible. And you know what? If that's me, I can take it. If you want to tell me it's me, I can take that, because I've taken that my whole life. But don't tell me it's the responsibility of a 10-year-old sitting in a classroom today to pay for her abuse when you have the ability to do something about it now. Representative Leach, I have so much respect for you, and with that respect, I want to combat something you said the other day. You said the states around us are locking down on this a little better than us, and we need to catch up. But none of us seem to understand the reality of the size of this problem. We don't need to catch up. We need to lead. We need to do more. We need to clarify what the hell is grooming? Who knows? Who can raise their hand right now and say, when you see this happen, this is the time to call the police? No one can do that. Nobody knows. There's no education in it. There's no clear guidelines, clear boundaries. So these kids sit there and get abused while people watch them be prepared for abuse for years and do nothing. Something's got to give, and I'm not asking for it to give for me. I'm fortunate enough to be able to pay for what I need. I'm fortunate enough to have someone watch my kid while I come here. I'm fortunate enough to have friends listen to me bitch about this day after day after day and still encourage me. But most people who have been through the things I've been through are not. So 4 days from now, 5 days from now, I want you to think about this moment and think, man, I would still be listening to testimony if all of them had lined up out the door, wouldn't I? Because that's the reality. You couldn't pack us in this room. You couldn't pack us down the hall. You couldn't pack us in 5 more rooms. It's everywhere. I'll get off my soapbox. I don't want to, but I will. We've got to do more. Leaving it like it is telling the kids that are being abused that they are responsible. And I've been told that I was responsible for long enough. I'm about done.
Yeah. Oh, Callie, thank you. Thank you for your testimony and your courage. You are truly a badass, Callie. You really are. I've never ever
Make sure
said
that's
that.
written down in record. I'd
I've
like a
never,
certificate.
I've never said that, but I mean it. You are, and you make me want to run through a wall on this issue. And you know, I think all of us feel that way. We want to bear this burden with you and shoulder this sense of great responsibility we have to make this wrong right. I think for us, it's what's the right thing to do? How do we attack this problem in the right way, in the most effective way? And not just to make ourselves feel good for doing something, but for doing the right thing, to provide justice for people like you, but to also deter this activity in the future. Members, questions for anyone on the panel? Yes, Representative Little.
Thank you. Mr. Extra, thank you for your comments. I'm taking that to heart. I think section 118.002A3 is too broad, and I think it's surplusage, and I'm going to submit a committee substitute to address that. I see your concerns, and I appreciate you bringing them forward.
Yeah.
We appreciate that.
Yep. Thank you, Representative Little. Members, other questions for the panel? Any? All right, thank you. Thanks to each of you, and look forward to working with you on this. Callie, thank you again.
Thank you.
Absolutely. You're welcome here anytime. All right, the chair calls Kristen Bentley, Charlie Ginn, Amy Glover, and Daniel Hunt. Mr. Ginn, let's start with you. I've got you here on behalf of the Texas Trial Lawyers Association registered for the bill. Is that correct?
That's correct.
On behalf of TTL and yourself registered for the bill.
Correct.
All right, go ahead.
Thank you, Mr. Chair. Good afternoon, committee.
Thank you.
Appreciation to Representative Little for the bill and for what it does. My mother is a teacher, and I know the great work that our teachers and our educators do across the state. I treasure and cherish my mentors that were teachers. Because of the relationships and the position that they are in, they have an opportunity to do that. But because of the position that they are in, they have the opportunity to groom without any accountability. To groom without any accountability. When I pulled the Tex Ed agency statistics, the 1,800 reported incidents, 42% happened in high school, 34% were in middle school, 24% were in elementary school. 24%. And I think that when we look to affect change, that's an important thing. But to affect change, you have to have accountability. Change without accountability is not change. The best position, the best people, the best agencies that are in the position to affect change on this bill have been correctly identified by Representative Little because they get to set the standards. If you want to motivate our school districts, give them a reason to care about what's happening, because when you look at the numbers and you look at the damage that is being caused to our children, it is clear that there is not much motivation. This committee specifically, this legislature has done a lot of things to protect children. It is important to, I know everybody on this panel, what I would say is this: we let our kids spend the majority of their time in schools. Why would we strip their protection when they're away from their parents the most? I want to answer one question that Vice Chair mentioned earlier. The Stowers doctrine, and then I'll be quiet, Mr. Chair. The Stowers doctrine does not apply to caps, because a cap is a cap is a cap. And so when you negotiate under a cap, it is a chilling effect, because there is an understanding that no matter what happens, the cap is the cap. I wanted to clear that up.
Yeah.
Not to in any way lock horns with Representative Little on legal principles. I'm not willing to do that, but I wanted to clear that up.
Sure. Thank you, Mr. Ginn. Kristen Bentley. Kristen, I have you here on behalf of yourself, registered for the bill. Is that correct?
That's correct.
Okay.
Thank you, Chairman and members of the committee. My name is Kristen Bentley, and I'm the State Republican Executive Committee woman for Senate District 1, and I chair the legislative priority for the Republican Party of Texas, Stop Sexualizing Texas Kids.
Hey, Kristen, just for the record, I have you here on behalf of yourself. I know you've identified yourself as that, and that's fine, but I have you here just testifying on behalf of yourself. Is that okay?
That's correct,
Okay,
yes.
go ahead.
Thank you. And Chairman, I want to thank you so much for scheduling this bill for a hearing. Representative Little, thank you for filing this bill. I had prepared testimony, but it's just, I think all of us, I think, are just moved very much by the previous testimony. I'm a former educator. I have a master's degree in special education. I taught moderate to severe special education. And it is so hard to see what's happened to my profession. I just want to say that. It has changed, I think, over the last 10, 20 years, and we have to correct it. I think we absolutely have to correct it. One of the things that I know that y'all do as legislators is that you identify problems and solutions. And we know that we have a problem. We know just by turning on the news every day or going on to X or wherever it is that we have a problem, because we have so many of these cases coming up weekly. The last I looked, it's on average, 3 sexual misconduct cases, arrests per week since January of 2025. It's a crisis. We are in a crisis. There are 2 reasons why this solution makes sense. Again, you are here for the solutions. Real children are harmed, and we know that outcomes for children are improved when they get the right help. And liability will allow children to get the right help because the right help costs money. And many parents might be able to afford the kind of counseling that's required to help a child through this, but many cannot. Many cannot. What happens to those children? We know this is a deterrent. We know that y'all can put more laws on the books, but we know that if there is no accountability, they will not follow them, or they're less likely to. We know that civil liability will ensure reporting. It will ensure background checks. It will ensure that school districts are doing their due diligence to make sure that they call a previous employer, to make sure that that previous employer who now wants to work, or that employee who wants to work with children was not fired for sexual misconduct, which happens. That happened in a case in Cass County, Texas, up where I live. I think my time is up, and I want to respect
Okay,
that.
thank
Yeah,
you.
Thank
Thanks,
you.
Ms. Bentley.
Thank you.
Great testimony, thank you. The chair calls, is it Shannon or Amy?
Amy.
Amy, okay. Amy Glover, I have you here on behalf of yourself, registered for the bill, is that correct?
Yes.
Okay. Go ahead.
I am a mother of children in Georgetown ISD, which is not very far from here. And I am in support of HB 4623 to remove some of these immunities, because right now our kids are at risk in the system that hides misconduct while they continually put out press releases and statements that the safety and well-being of the children are their top priority. In 2023, I posted in a private mothers forum about district concerns, and within hours, I had a cease and desist letter using non-public data, followed by a multi-million-dollar lawsuit. Despite my compliance with those, I am one of many that has been targeted, and our case is still ongoing. ISD leadership refused to investigate, and in the last year, our ISD alone, we've had sexual assaults, physical assaults by educators against our students, weapons on campus, arrested educators that are currently still teaching, educators who have publicly defied policy that are still working as of this week, and interviews occurring right now with 6th grade students without parent consent or knowledge that it involves an educator's misconduct investigation. Even with the evidence, parents cannot win. ISDs will self-investigate, reject proof. They will delay open records by using the Attorney General, or let their employees resign without scrutiny. Immunity blocks us in court. Attorneys will not take our cases, as you guys have heard today. They know that the Texas Ed Code is over 2,400 pages, and it often favors schools. Can I say one last part?
Yeah,
okay,
absolutely.
sorry.
Yeah, you get 30 seconds.
Currently, we also have HB 1842 allowing for districts of innovation, where they have exempted from laws including teaching certificates, and under Texas Ed Code 22.085 subsection B, they are currently allowing felons to work, Title V violent offenders to work with pre-K through 12, so long as they have met the conditions of the court and the crimes were not against a minor. So per TEA's own admission, we have many felons currently working within our ISDs without oversight. So we feel that, I do feel that this bill would help make things more accountable.
Okay, great. Thank you, Ms. Glover. Members, any questions for the panel? All right, thank you. Thanks to each of you. Is Daniel Hunt here? Okay, the chair will show Mr. Hunt as registered for the bill but not wishing to testify. Okay, our final panel, Shannon Ayers, Ann Newman, and Catherine Sarter. Ms. Ayers, let's start with you. Have you here is Shannon Ayers on behalf of Citizens Defending Freedom and yourself, registered for the bill. Is that correct?
Yes.
Okay, go ahead.
So yes, my name is Shannon Ayers, and I'm the State Education Director for Citizens Defending Freedom, and I'm here in strong support of HB 4623 because there's no defensible reason, legal, moral, or ethical, to shield public schools or school employees from accountability when a child is sexually abused under their care. I have a whole speech here that I wrote, but again, the testimony before, the prior testimony was pretty powerful and said pretty much everything. So I just want to address a couple of things. Ms. Flores said earlier, she talked about hiring practices. I think it's worth noting that there are no standard hiring practices for teachers. There's a background check that's done at the time of them getting certified, but beyond that, I don't believe there's any standard vetting process. You mentioned, Representative Leach, the do not hire registry. I don't think there's any rule or law that says that they have to check that before hiring a teacher. So I think that needs to be something that's looked at. The system creates and breeds a culture of secrecy because it's designed to protect itself. And so, I have one example in a very small rural school district where a teacher reported what she suspected to be abuse of a child, and she was the one that was punished for reporting it. It's not encouraged to report this kind of abuse. I'm hearing anger and righteous indignation from this committee, and that's great, but it's not enough. You have the power to fix this, to do something. Parents and victims are watching you to see not what you say, but rather what you do. So I'll finish just by saying thank you, basically, to Representative Little for refusing to protect those who harm children. Choosing accountability over immunity is the kind of leadership that we need from all of you. And so I am asking you to allow him to show you the way. I urge you all to follow his lead unanimously and pass HB 4623 for our children. Thank you.
Thank you, Ms. Ayers. Ann Newman, I have you here on behalf of yourself, registered for the bill. Is that correct?
Yes.
All right.
I've been coming to Austin to testify and watch legislative issues for about 35 years. And what I've observed is legislators tend to treat symptoms, not root causes. I like to look at root causes. For example, allowing teachers to resign to, quote, avoid legal action. Schools investigating themselves. $1 billion for safety, not one dime for protecting children from predators. Laws in 2017 and 2019, it strengthened the laws, but the problem is worse now. I urge you to listen to the testimony yesterday of Matt and Koviak, I'm not sure I got his name pronounced right, yesterday on Senator Betancourt's SB 571. From a 30-year law enforcement officers with amazing credentials. He exposed the corruption, how schools are covering up these crimes. And by the way, schools shouldn't be protecting themselves, investigating themselves. They're not qualified to investigate crimes. The report should go to law enforcement. The grievance process is atrocious. The parents are not on a level playing field. I urge you to read the Texas Ed 991 report, and the solutions we developed are on the back of it. Ask the commissioner what he has done for the last 10 years that he's been the commissioner. Ask what's fueling this epidemic. Treat it as institutional betrayal. Treat it as corruption. Treat it as lack of accountability, because it is. I spent an hour and a half this morning talking to a doctor who asked me what's causing this. I don't have an hour and a half with you. I would love to sit down and have an hour and a half with you alone or together. Thank you.
Thank you.
And thank you very much for your concern.
Thank you,
And
Ms.
Mitch Little.
Thank you, Ms. Newman. Catherine Sarter, have you here on behalf of yourself, registered for the bill?
Yes, that's correct.
All right, go ahead.
Thank you again, Mitch Little, for filing this bill. Good afternoon, committee members. My name's Catherine Sarter, and I'm the mother of a 6-year-old child who was physically abused by his special education teacher. I will never forget walking in the front office of Bee Cave Elementary on October 29, 2024, to pick him up for an occupational therapy appointment. I found him crying with a torn and tattered shirt and a large bruise on his chest. The result of which I would soon learn was the abuse at the hands of his special education teacher. The pain in my child's eyes that day is something I will never forget, and I felt it through Kelly's testimony. And the shame lies not only with that teacher, but with Lake Travis Independent School District, who hired this teacher knowing of his previous 2 assault arrests, then who allowed him to resign quietly rather than being terminated by the board for harming my child. The abuse was captured on classroom video. The teacher stalked my child like an animal stalks its prey, is what CPS wrote in their report. He lifted my child up in the air, he threw him on the ground, and he shoved a table at him where my child had to jump out of the way. Thank goodness for all that jujitsu training. Despite district administration viewing the footage the very next day, the district delayed turning it over to law enforcement within the district until October 31st. I kept my son home after the incident, but because the district failed to act, he was returned to the same classroom with his abuser for the next 2 school days. They knowingly and negligently left a child in harm's way. The district prioritized legal risk over my child's well-being. They tampered with evidence, withheld records, they've denied trauma services, and they continue to resist accountability. House Bill 4623 is critical. It removes the legal immunity that shields the public schools and staff when children are harmed due to negligence or outright abuse. It gives families like mine a clear path to justice when the system fails us. Please pass this bill for my son, for all the children who suffer in silence, and for every parent who believes their child should be safe at school. Thank you.
Thank you, Ms. Sarter. I'm so sorry about your experience and your son's experience. We appreciate you being here, though, today. Members, are there any questions for this panel? Okay, thanks to each of you. Does anyone else wish to testify on, for, or against House Bill 4623? Seeing none, the chair recognizes Representative Little to close.
All right, thank you, Chairman Leach. Thank you, members of the committee. Obviously, we've got a lot of work to do here. There are a lot of things to think about. I'm fortunate enough to work with such brilliant colleagues that are thinking about all these issues. I ask you to consider it carefully. As I said to Mr. Exer while he was after he finished testifying, I think if you look at 118.002 A3, the section that begins any other negligent, reckless, knowing, or intentional act, I could see how that would be overbroad. It would certainly be surplusage as it relates to the sexual
Test. I cannot hear myself. Test. F2 might. Get rid of that shit. How about now? I don't know what the fuck. How about nah? Fuck.
Conduct issue, and
Does not appear that my shit is working. How about now? How about now? Test. Alex, can you hear me in there? Alex Goff, can you hear me? Alex Goff. Well, I don't know if anybody can hear me. Comment in the chat if you can. Otherwise, we'll keep it rolling. Keep it rolling, bud.
Perhaps a more narrow approach would be a more effective one, and we can propose a committee substitute on that basis.
We are back. We are bringing Doug back. Damn it.
Happy day.
Is there an echo? There's an echo in there also. There's an echo. There's an echo. Fuck. How about now? Can you still hear an echo, Nolan? What about an echo now? Test. Damn it. How about now? Test. All right, what about now? Still same? You know what, it might have been. Fuck. Oh, now we're good? Maybe I fixed it. Thank you, Nolan.
Hey, y'all, we are back.
We'll hear from the panel, and then you can proffer any questions you have once the panel's done. Sir, your name?
David Finolio.
David Finolio, I have you registered testifying on behalf of yourself
Back up and
against
running.
the bill. Is that all correct?
Yes, sir.
Okay, and go ahead and begin.
Most of the co-tenants don't know their rights, and they've been financially abused by.
Okay, that is just talking about wills, I think. So, still waiting on the tort reform trucking bill. I will update you guys accordingly. So a little bit of lag in my microphone. But we're still kicking along, still fighting, doing our thing. If you have come over from YouTube, or you're on YouTube, If you come over from Instagram, we are glad to have you. Thanks for joining us. Thanks for staying up to date. Ask questions if you can in the chat. Mostly just me. Going a little crazy. Always good to have someone to talk to. I feel like Andy in the office when he leaves on that sailboat by himself. But that's okay. That's why we're here. I hope this does provide some entertainment to somebody. I am right now, although the testimony is going, I'm trying to figure out an issue I'm having with my microphone. So bear with me, kind of jumping back and forth with the chat. I'll actually pop open this in a new window so I can see it if you're with me. Change that to live chat. If you are with us, please let me know in the comments. I'll drop a hello so everybody can see it. All right.
Not ever going to settle with my brother, and I would be either in court to this day or dead, as he predicted. And Mr. Fenolio and his staff led me by the hand, helped me in every way. We had good legal representation, and we petitioned the court for a partition. That partition took another 7 years. $1.2 million in legal fees only. I mean, it was such a dramatic turn of events to try to get a settlement. We feel like this bill, with the revisions that are proposed, further alienate the time, particularly in the 10-year appendage that would be placed on that land where no one could do anything with it. Why would Mr. Fenolio have ever agreed to a buyout if he knew he couldn't do anything with a 10-year land purchase? I mean, I certainly wouldn't buy that, so I know that there would be no third-party buyers out there. And then there's numerous other parts, like Mr. Fenolio, as a non-heir owner, would have to own 50% of each tract of land, and there were 43 tracts in this settlement to be. Anyway, as I wrap up, I will tell you that I feel like that I would have been targeted as a non-participant had a third-party buyout and a petition of 23A to Texas Property Code. And so I appreciate being able to talk to you about my story today. I will tell you it was not an easy one in any way.
Yes, thank you, Ms. Phillip. No, I do appreciate that. And thank you for sharing your story. I know it's been a long day waiting, and we still have, as you notice, you see that the room is not empty, so we have a long way to go the rest of this afternoon.
We wanted to help other people in our
I appreciate
position.
you weighing in, and so.
Thank you.
I hadn't used the timer, but I do want to make sure that we keep everything and I won't do it unless I have to, but just want to try to keep everybody on track with, we have quite a schedule still left to go. But important to hear these stories, so I appreciate you being here.
Thank you.
Rebecca Honsinger, is that how it's said?
Yes, sir.
Okay, and I show you registered to testify on behalf of yourself and against the bill, is that correct?
Yes, sir.
Okay, go ahead and begin your testimony.
My father and my two aunts were left a third of each of their parents' property and a third of each house. The house that my father was given to live in did not fit the needs of my mother and father and had back property taxes, which my parents couldn't afford. The house was too big, the layout did not work because they had minor medical issues. For several years, my dad was fighting his sisters
to get the houses separated so we could move forward. But they had become estranged because of all the issues that we were having with the properties. My family continued to struggle financially trying to get the property taxes back down. And we were at risk for foreclosure. We couldn't afford the taxes, so we surely couldn't afford an attorney. In the meantime, our property continued to require more maintenance that my family could also not afford. This is that my father found someone that would buy my father's shares, the property that would take the battle with his sisters. Having this non-family member enter the picture immediately lifted a burden off of my father and my family's shoulders and allowed him to protect some of the value of his inheritance. If it wasn't for them, we would have walked away with nothing. We wouldn't have known what we were gonna do, to be honest. And then in the end, the 3 properties were divided equally after an agreement that we could not reach until a third party was involved. Slowly over the course of time, my father rebuilt his relationship with his sisters. The law you are discussing would put so many barriers in place for my father to sell his land to a non-heir. We would undoubtedly have lost property to foreclosure. If this was the law, we would have went through this. It's protecting my aunt's property rights by reducing my father's rights is very unconstitutional.
Thank you. Appreciate your testimony. Daniel Burke, correct?
That's me.
Okay.
Yes.
I have you registered testifying on behalf of yourself against the bill. Is that all correct?
Yes.
Okay, great. You're on.
Okay. Thank you for your time and attention, members. My name's Dan Burke. I'm an attorney from San Antonio.
Can you get the microphone?
Hello,
It's a
Dan.
directional mic. Just make sure that we're getting what you're saying in there.
Is this better? My practice focuses mainly on real estate. I've been practicing 22 years. I've done over 500 files with disputes related to real estate. I use partition in those lawsuits as well as in negotiation. I probably have filed a lawsuit for partition less than 10 times in all those suits. But it is a
I don't know what partition is or what's the context, but this is kind of interesting.
tool to be used in the toolbox. I'm against House Bill 4011. The version in front of you has several problems in my opinion, and I was just going to highlight them, and I'll try and be brief.
No, I think that would be great if you can bullet those out, because that's where we try to kind of drill down into those details. And I think the stories give color to that, but since you're the lawyer and practitioner, I think that'll be more helpful that way. Thank you.
I'll do my best to be succinct. The first problem, in my opinion, is the 50% threshold combined with the 10-year moratorium. In brief, the bill, as currently written, says if you own less than a 50% interest in the property and you are a non-heir co-tenant, you cannot file for partition until you've owned that interest for 10 years. The practical effect of that will be to diminish the heirs who want to sell their interest in the property, because if you can't acquire more than 50%, someone like Mr. Fenolio will pay even less for that share of that property. And ultimately, with that in place, because of the diminished value, in my opinion, and I'm not a constitutional attorney, but in my opinion, it would constitute a taking and a violation of the Fifth Amendment of the U.S. Constitution and Article 1 of the Texas Constitution. So that's the first point that I have a problem with. The second point is, it requires a non-heir plaintiff who files a partition action, no matter what, to pay all of the defendant's attorney's fees. That's punitive. They do that to discourage the lawsuit. They do that to punish the non-heir co-tenant. And in my opinion, that violates the open court doctrine that the state of Texas adheres to. And it also reserves partition only to the ultra-rich, because before you ever tee it up, you're going to have to be able to pay your attorney, as well as the attorney of one to who knows how many defendants. The final point, the procedural steps that was mentioned previously. It adds approximately 20 additional procedural steps. Each one of these steps will add probably 2 to 3 weeks, up to 2 to 3 months, depending on the court you're in. Over the life of the case, you've just added 12 to 24 months with these additional procedural steps before you'll ever get resolution. Further, each one of these steps adds an additional cost, which is on top of the attorney's fees that they're already mandating that the non-heir plaintiff must pay. Those are the 3 points that I wanted to make. I'll be happy to answer any questions.
No,
If
Mr.
there are
Bryden, I
none.
appreciate you laying those out in that way. Allows us to kind of digest things. Members, for this panel, do we have any questions? No? All right. Thank you all so much for taking the time and appreciate your patience.
Thank you.
Yes, ma'am. Is there anyone else wishing to testify for, on, or against House Bill 4011 at this time? Chair sees none, recognizes Chairman Darby to close on the measure.
Thank you, Mr. Chairman. Members, the automatic attorney fee provision requiring non-heir co-tenants to pay legal costs, while it may seem punitive, it's rather compensatory in nature. Heir co-tenants forced to defend against partition, actions initiated by non-heir owners.
His senator on the far left, his suit is really bright. That is a bright, bright blue. Jesus Christ. I kind of like it though. How are we doing on YouTube? Is the stream coming through okay? We have 0 viewers. That's okay. Keep plugging along here. Keep working. Doing our thing. All right, we are still waiting on 4680.
Typically lack the financial.
4680.
Their role is to
I'm
board
having
incoming
to-
ships and assess local conditions such as tides.
Boarding ships, Michael Bolton tells us about that one. Let's take a listen in. This could be big. Could be pirates.
The issue that's happened, members, is the statutes that this bill wants to update have not been changed since 1995.
Oh, I need to change the
And
bit
so
rate.
the committee substitute for House Bill 2680 assists the pilots by modernizing the regulatory framework to support future growth. First, it's a blanket statement that incorporates the provisions of the
What's the
current
bit rate?
Transportation Code,
All right, we're
Chapter
good, we're good.
62, into Chapter 65. This streamlines cross-references and ensures that Matagorda Bay pilots have their own clearly defined statutory framework. Secondly, it's the alignment of the statute with other Texas state pilot statutes by removing outdated provisions and updating language for current operational practices. Third, it revises Section 65.01 to remove the previous cap on the maximum number of pilots while still maintaining the essential requirement of a minimum 2 pilots at all times, and removal of the obsolete provisions It expands the definition of navigation district to clarify that their service extends to vessels navigating any waterway within Matagorda Bay and Lavaca Bay, ensuring full jurisdictional clarity. There's a cleanup bill to modernize a statute that hasn't been done so since 1995. Members, I do have.
A statute about what? A statute about pirates? What the fuck? Legislating Jack Sparrow. Let's get to the trucking bill. The shit that matters. I do like this guy's shirt.
I believe a witness and a resource witness representing Matagorda Bay Pilot Association who is here to answer any questions.
Speed this guy up.
Thank you, Representative Lozano. Of the legislation, is that all correct?
Yes.
Okay, go ahead and.
This guy hates pirates. 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 He hates pirates. That's why he says
Begin your comments.
Okay, Chair, committee members, thank you all very much for allowing me to testify today. Good afternoon. My name is Captain Michael Harris. I'm the presiding officer of the Matagorda Bay Pilots Association.
Whoa.
I'm here to.
Okay, maybe this is not about pirates. This guy actually sounds like a total badass.
To express strong support for House Bill 2680. For over 50 years, the Matagorda Bay pilots have safely guided ships into and out of Point Comfort, Texas, in Calhoun County. It's a 23-mile-long ship channel that spans through Matagorda and Lavaca Bays. We are duly licensed by the United States Coast Guard and by the state of Texas. And as Representative Lozano said, we do get our commission from the governor of Texas. This legislation proposes essential updates to the Matagorda Bay Pilot Statutes, which is Chapter 65 in the Transportation Code. It has not been updated since 1995. This bill will help modernize our regulatory environment and support future growth. The updates are critical for ensuring that our statute remains effective, current, and consistent with industry practices. It removes outdated restrictions and clarifies the operation, training, and liability standards which have existed for other pilot groups in Texas since 1995. This bill will help ensure safe and efficient pilot services in our vital waterway. We do have resolutions of support from the Calhoun County Judge and Commissioners, as well as from the Calhoun Port Authority, and a letter of support from the Texas State Pilots Association. Thank you again for allowing me to testify.
Thank you, Mr. Harris. Members, do we have questions for Mr. Harris at this time? Nope. All right. All right, I've got you registered as Brenton Allison here testifying on behalf of Matagorda Bay Pilots in support of the legislation. Is that correct?
Yes, as a resource witness, Your Honor. No, sir.
Well,
Representative.
I'll take all that. That's fine. So just to answer any questions, so if there's any technical questions, anything that anybody wants to address, you got off easy? All right. So is there anyone else? Y'all gentlemen are done. Thank you. Is there anyone else wishing to testify on, for, or against House Bill 2680 at this time? And Chair sees none and recognize Representative Lozano to close on the legislation.
Thank you, Chairman, Your Honor. Unless there's any questions, I close.
No, thank you. Members, I think no questions. All right. Thank you very much.
Thank you, Chairman.
Y'all have a wonderful day. Chair withdraws committee substitute to House Bill 2680 and leaves House Bill 2680 pending at this time.
I have no clue what that bill was about. All I know is that pilot sounded like a badass, but the Jack Sparrow bill passes. Through committee, at least. So, quick story for everybody. My computer crashed yesterday, and now I'm having to reinstall everything. Was in a bit of a rush this morning. And logging into Amazon, YouTube, everything is a pain in the ass. I mean, this shit sucks. I gotta go through, I gotta re-download Adobe, I gotta download McAfee. My Adobe doesn't work. Trying to fix that right now. If you know how to fix Adobe, please let me know in the chat, because I do not understand how the hell to do this. Let me try that. What's this guy saying?
Dispute over sovereign immunity to an appellate court, often delaying the
Sovereign immunity. Who cares? Although it sounds probably pretty important. I don't know what he's talking about. All right, we're going to go ahead and log off the chat because there's nobody here, not even my wife. I think Austin Smith was going to join, but he was working on a class action complaint, so he's pretty busy. Not a lot of class action trucking cases. Although he has a lot of really cool cases. Just settled a big case where a Dodge Charger, I think it was, killed a lady. Very, very sad case. It wasn't actually the car, it was part of the car. It was some kind of seat or something. Maybe we can have him on the live stream just to talk about that case. It was very, very interesting. He had to kill himself basically to work it. Everybody wants to do these big product cases, but man, seeing the work that guy had to put in for it, whew, I had no idea how difficult those cases can be. I'd love to have him on here to tell folks about it, because it was crazy. I mean, I think the dude took like 20-something depositions, had like 20-something hearings. These big corporations, they don't want to pay, they don't want to take responsibility. But Austin held them to it, held their feet to the fire. He's doing another class action about Galaxy Gas. You might have seen me cover that on YouTube. So he's filed that one. I think he'd be a really cool person to interview. Because the class action cases are not about big money or big medical bills or disfigurement, loss of consortium. They're really about holding big public companies accountable, because the only way they can be held accountable for mislabelling a product or selling a bad product is a big class action case, because they have to pay to remedy whatever product they had that failed. I think generally, I'm not a products guy, but could be something interesting. Somebody we need to talk to, get his viewpoint. All right, I am back into my Amazon account. Thank God. I was struggling. All right, I just ordered a Stream Deck. Anybody on the live stream use a Stream Deck? Oh, Austin's here. Let's go. Hello, Austin. Thanks for joining, my friend. We were just chatting about you, telling the YouTube world a little bit about your practice, a little bit about what you do. Let's check in on the hearing.
Depositions and
this is still sovereign immunity. This mustache is sexy. That thing is awesome. I need to get a mustache. What do you guys think? You know, I might throw on a mustache right now. Maybe that's what we're lacking. Get back to our roots here. Get back to what made this channel great. Make mustaches great again. There we go. That's a good one. Because there's a lot of truck drivers that have mustaches, so maybe this will keep the people informed, keep people entertained. So as much as we love talking about tort reform, this is about keeping the people entertained. There we go, baby. All right, that's just for you, Austin. Got that mustache on, baby. Oh, it is It is itchy. That is, ooh, I'm not liking that. Okay. What was I doing? All right, doing some accounting stuff in the background. Not the most fun thing you can do, but a bit of a necessary evil. You know what I'm saying? Running a business as a solo here, you got to do a little bit of everything. Got to do the accounting, got to do the payroll. God, this mustache is real itchy. Whew. Let's update Instagram that the mustache is on, that we're still talking tort reform. I think I'll tag Mr. Smith in this post as well because he inspired the adding of the mustache. All right. So apologies.
Contend someone has walked.
All right. New bill 4081. Let's listen in on this one.
Off the job with your company's trade secrets. Naturally, you might want to sue to prevent the retention, use, or disclosure of those trade secrets to unauthorized parties. One of the elements of your claim, though, is proving that the information is actually a trade secret. And sometimes that may be in a document, and you may need to put them into the record as a summary judgment exhibit.
Oh, this is the bill author. The reason I recognize him is I watched him debating on a tax issue on the House floor the other day. So he must be the bill's author.
For example, or an exhibit to some motion. While Rule 76A of the Rules of Civil Procedure permits sealing of court records, I'll be honest with you, it's long been my view, practicing in this field, and everyone I've ever...
76A, Austin Smith, live in the... Well, he left us. Well, Austin Smith, who's in the chat earlier, wrote a law review article about 76A. I bet he would love to talk about this bill.
Spoken to that the rule is clunky. Before you can seal them, you have to file a separate motion and hear the motion 14 or more days later. While you could obtain a temporary sealing order, there's no guarantee your temporary sealing motion will be heard by the time you need to file your trade secrets. And so it just doesn't work well. House Bill 4081 is designed to make the process work well. It ensures that there is not a risk of your trade secrets being disclosed to the people you're trying to keep them from being disclosed to when you need to attach them to a motion, while still at the same time protecting the right of the public, including the press, to challenge the sealing by motion. Here's how it works.
Yeah,
You basically, if you've got a document you contend is your trade secret that you need to put into evidence as a summary judgment exhibit, for example, you would file your motion, and with that motion for summary judgment, you would file a motion to seal it. Basically, it's an notice that you're sealing it and an affidavit.
There's the problem. This clogs up the court system. I've had to argue these before, these 76A motions. They are so annoying and unnecessary.
Generally discussing the document and proving up that it is a trade secret. Basically, that you take the reasonable method to protect its secrecy. That gets put on the public record, and then it's sealed right then and there. And you put it in a sealed envelope and give it to the court. If somebody wants to challenge that, it's obviously on record. They can come in later and do a motion to unseal it, and they've got the affidavit that they can then challenge. Hey, I don't think these documents really are trade secrets for this reason. And then you would hold a hearing. But it takes away the burden on you having to get an order before you can put it under seal, and having the uncertainty that before you need to use this exhibit, that you might have to disclose it to the side you're trying to keep it from being disclosed to. Pretty simple bill. It also protects the right.
Aren't they going to see the trade secret that they're suing over? What are you talking about, dude? The other side would seal the trade secret that they're alleging was stolen from them. They've already seen it. They already know about it.
Of individuals that if you got a document you contend is your trade secret and the other party wants to use it, they just flag that and then you subsequently do the affidavit. Pretty simple process, and happy to answer any questions to the extent you have them. I don't know if there's any witnesses on it. 2 people, I think, registered and they were like, this is awesome, and nobody said it was bad, so it's a great bill. So happy to answer any questions.
Yeah, it seems like a cleanup bill to me. Members, do we have any?
Simple little cleanup.
Yes, Representative Hayes.
Thank you. Chairman Vasu,
Yes, sir.
on page 2 of your bill under subsection C,
Yes.
it says, you were talking about the process. It says 14 days after the date a person alleges a document has trade secret, then they file a notice. And it says they file the notice with the trial court and the Supreme Court. Why both?
Well, I think that wasn't my request when I put this into Ledge Council. I think what Ledge Council was thinking of is that is what's done for Rule 76A, is you have a notice that's posted at the courthouse where the notices are, and you post it to the Supreme Court, okay? And I think they were just...
Yeah, he's right. He's right. Okay. Reason you post the 76A notice is so that the public, like the news, can show up and say, no, this is not confidential. This should not be under seal. The public deserves to know. Austin Smith, who was in the chat earlier, did a whole law review article about how this was abused by the oil companies as a way to hide harm from the public. I wonder if I can post that article. It was a really great article that he did in law school about why it should be disfavored. I completely agree with him. I have only seen it a couple times, but I hate it. I think it's stupid. It should be banned forever. You know what I'm saying? Comment. I know what you're saying. If you know what I'm saying. Okay.
Just copying that over. One practitioner has reached out to me that I've worked with and said, you know, maybe we should just file this notice with the trial court because obviously it's going to be tied to the case. Why do we need to put it with the Supreme Court? So to the extent you agree with that and you want to do a committee sub to strike out the Supreme Court reference, that's fine with me.
Thank you.
You bet.
Or as a floor amendment.
Fair.
Just trying to help. Any other questions? No? All right, I don't have any witnesses registered to testify on for or against House Bill 4081 unless there's anyone that wants to come forward. I don't see anybody. So if you'd like to close, you can close.
I close.
All right. Chair leaves House Bill 4081 pending at this time. Chair lays out.
Ugh.
And Ms. Weiner, I do see you sitting there. I just am going to move a couple of bills that have no witnesses registered. So,
all right, we still have nothing on the trucking bill. Why is that? It's 3:42 p.m. People getting tired. People aren't going to show up. They do this on purpose. Leach isn't here. TLR isn't here. Schofield isn't here. They're going to push this one away, folks. They're going to do it again. Let's see what this one's about. HB 2203.
Committee, I am honored and blessed to lay out House Bill 2203 today, which aims to include land surveyors alongside architects and engineers and limiting liability clauses within construction contracts.
Oh my God, yeah. Let's protect the land surveyors. Who the hell is suing a land surveyor? What the hell? Come on, what a waste of time. That's all. More and more protection. That's all we need. More and more protection. Pretty soon you're not going to be able to sue anybody for anything, which is really what they want. I mean, keep in mind, that's what the oligarchs really want. They want to keep you quiet. They don't want you to hold them accountable. All right, I'm about to buy some new equipment here. Give you a sneak peek. Let me know in the chat if you use any of this stuff. Whoops. Amazon shopping cart. I'm going to get a microphone cover, stream deck, get some headphones and a real mic because this one is running out of battery. Headphones run out of battery, so pretty excited about that. Let's go back. But let me know if you've ever used any of that stuff before. Really appreciate the feedback. Really just going based on what Reddit is saying.
Be included when you have engineers already, because they're doing all the topography and
Absolutely.
drainage and things like that that impact. And if it was fair to exempt them, and it would be fair to exempt the surveyor. So thank you.
I agree. Thank you, sir.
All right, members, do you have any other questions or comments? No, I don't have anybody registered right now, so let me just make sure. Is anyone here wishing to testify on for or against House Bill 2203 at this time? The chair sees none. Recognize Representative Baumgartner to close.
Well, with that, I hope for
Representative
consideration on this bill, and I close. Thank you.
Thank you, sir. Chair leaves House Bill 2203 pending at this time. Chair lays out House Bill 4139. Recognizes Representative Zwiener. Oh, hold on. Chair lays out.
I think these are all I think Moody said this. This is all bills. That don't have an opposition.
The committee substitute to House Bill 4139 recognizes Representative Sweener to explain the substitute. I apologize for the delay.
Thank you so much, Chairman, Vice Chair Johnson, and the rest of members of the
You're welcome.
JCJ committee for the opportunity
What about Golfball YouTube channel? Well, we don't get a thank you, huh? We're giving you time. We're giving you space.
to lay out House Bill 4139. House Bill 4139 comes out of a bad experience we had in my district related to courtroom proceedings being live streamed during the preliminary portion of a sexual assault trial for a minor. And there were concerns around multiple elements. We will have the DA from Hays County here to testify a little bit about that experience as well. But I think the challenge we're facing is that during COVID, live streaming portions of court proceedings or otherwise using audiovisual recordings became much more common. And this
Yeah, I agree with that. You shouldn't be able to live stream sex assault trials. That's messed up. Yeah, this should pass for sure. I'm a fan of that.
concerned about victims of family violence, sexual assault, having testimony about their experience being put on the internet. So this bill seeks to put some reasonable safeguards there.
Looks like we got someone
the committee sub is a cleanup bill.
in the live stream. Welcome. We are covering the Texas legislature. Still waiting on the trucking bill to be heard. No update as of yet. But please stay tuned. Thanks for joining us. Appreciate you. Drop a like, subscribe, and a comment in the chat. Let us know who you are, where you're listening from, and if there's any questions that you have. Oh shoot, there's no audio.
Inside of a trial courtroom, but the bench will be covered with electronic gadgets, all there to assist the court reporter in making a record. At the beginning of the trial, neither party knew that this was going on, but the judge began live streaming, in this case, during Fort Dyer jury selection, in which jurors are identified by name, speak on their personal matters. Of course, when they raise an issue that the judge needs to contemplate to decide whether to excuse them or not, they're called up to the bench. In this case, during this live stream, jurors were called up by name to the bench and asked and engaged in a colloquy with the court. Often it's not about deeply personal medical issues, reasons why a person might not be able to serve, medical reasons. That happened throughout Fort Dyer. A jury was selected and about to move into the next portion of the trial, which is opening statements. This trial would look like opening statements from each side, and then the first witness would have been an 18-year-old woman who was sexually assaulted when she had been 14. So now an adult, then a child. a chance remark by a judge in another court to a prosecutor who was not involved in this case. That judge asked this court chief, how do you feel about the live stream? The court chief was very much engaged in her own docket's business, closing that out that morning, and didn't really register it until she got back to the office, sat down at her desk, and asked herself, I wonder what he meant. So she started poking around as prosecutor. I don't know if you know any of them, but they're extremely nosy people, and they will go poke around and figure out what's going on. She found the live
Nosy people.
stream, currently streaming. Sent up a red flag, notified a chief of a court that was still in court so that she could rush in there. That chief rushed in, lodged objections with the court regarding the video stream. The court resisted taking any action. The court asserted its authority, and the court asserted its authority in the interest of transparency to live stream whatever that judge wished to live stream. We were very concerned about the vulnerability of this witness, not only over concerns about embarrassment, but true security concerns. And I believe that's true of all kinds of witnesses in all kinds of cases, not just sexual assault cases. The judge did turn off the live stream, and the trial was conducted, and we got to an answer, and all was well. But this part of the story is not that interesting. The judge then began a full court press in the media to assert that he had notified the parties and that I, in particular,
Sounds like the judge messed up, man.
he had not notified the parties. But I'm telling you, he did not notify either party. To me, that notice is probably as important as the existing substance in the bill that's before you. And I would encourage, well, I don't understand your process, but I hope by the time
Don't
y'all
worry.
get-
Most people don't.
Yeah. I would hope by the time you get to a final
Don't
product,
worry.
it will include a notice provision that requires the court to notify the parties some period of time, I would think 72 hours was appropriate, ahead of the hearing.
No, I appreciate you taking the time to be here, obviously, to kind of give us the real-world look at the situation that we're trying to address. Members who have questions, actually, let's do panel and then see if anybody has questions for anybody in the panel. Jennifer Lundy, I have you registered testifying on behalf of Texans for Judicial Accountability in favor of the legislation. And I think we're still sitting at, how many for the rest of the day? 40-something? Yeah, so we're still sitting about 40, 45 witnesses for the rest of the day, so.
I'll make it quick.
So just.
I'm less than 2 minutes.
45 witnesses. You know what that is for? That's for the trucking bill, which we still haven't frickin' got to. What a joke. Come on.
Whether it's a new bill, as we are needing audio and video in the courtroom and praying for legislation to be on this in an appropriate manner, not only for the protection of the people, but also for the protection of the judiciary. There have been so many very public complaints coming through social media, complaints that the judges cannot defend themselves on, further complaints about the State Commission on Judicial Conduct stating they are not reprimanding judges. We have got to be requiring audio and video of the courts, not live stream, and provide them to the SCJC. I primarily appreciate this bill carving out the areas that should not be publicly recorded. As a citizen, I know this is necessary. Thank you.
Thank you, Ms. Lundy. Members, do you have any questions? No? Okay. Sir, have you registered as Robert Garza?
Yes.
Testifying on behalf of?
Americans
for Judicial Accountability.
Yes.
Oh, the way it's entered here, and I have to ask your permission, is Director for Americans for Judicial Accountability is who you represent, but that's your position there.
Correct.
Can I change it to simply the name of the organization, Americans for Judicial Accountability?
Yes.
All right. Thank you very much. And I have you registered testifying in support of the measure. Is that correct?
Correct.
Okay, go ahead and begin your testimony.
House Bill 4139 is a necessary and measured response to the growing presence of courtroom recording. It strikes an essential balance between the public's right to open courts and an argument needed to protect the dignity, privacy, and safety of vulnerable individuals in judicial proceedings. This bill enhances justice, preserves constitutional integrity, and maintains courtroom decorum, setting clear, reasonable limits on when and how recording can occur. The bill protects the psychological well-being of victims, especially children and survivors of sexual assault abuse and family violence, by ensuring they are not forced into the public eye unless given clear consent. It respects their autonomy and protects them.
I think everybody be for that. I mean, it seems like a pretty easy bill to pass right here. I mean, right? I mean, there's nobody here, I think, that would oppose this type of bill. All right, guys, we are going to have to exit. I am out of here, I think. Unfortunately, we have not gotten to the tort reform bill. But that's okay. We will be back tonight. I got to go home, pick up the key. You know what I'm saying? I'll probably just delete this live stream because nobody's watching. But that's okay. It's good practice. Thank y'all, everybody that did tune in. Thanks to Austin who tuned in, no one who tuned in. Thank you to Alex that tuned in. Appreciate you guys. We